Hello, my name is Marc Sheridan. I'm a collaborative practice lawyer and founder of the New York Civil Collaborative Group. Collaborative practice has its roots in family law. Stu Webb, a Minnesota family lawyer, is credited with its creation in 1990 in an effort to come up with a better way to resolve divorce and custody cases while minimizing the emotional damage to the parties and their relationships with their children. This process of conflict resolution has grown exponentially in family law, resulting in the creation of an international community of collaborative professionals called the International Academy of Collaborative Professionals. Recently, it has branched out into other areas of civil law, including business disputes, employment, probate, and other areas. The cornerstone of collaborative practice is that everyone agrees, the parties, lawyers, and other professionals, that they will resolve the matter without litigation. The collaborative process begins by each side retaining a collaborative attorney to help the parties negotiate an agreement on all issues. Each attorney is trained in interest-based negotiation and mediation. Unlike a mediator, each lawyer is a counselor at law for their respective client, responsible for helping the client identify and advance their own interests and develop settlement options. Negotiations are conducted in a series of private face-to-face meetings in which both parties and attorneys attend. At the first meeting, the parties enter into a contract called a participation agreement, in which everyone agrees to fully disclose all relevant information with a focus on reaching a mutually acceptable settlement. Unlike litigation, the attorneys have an affirmative duty to share information and correct mistakes. If the parties cannot resolve the matter, both attorneys are to withdraw from representation because the collaborative attorney's role is to settle the claim, not litigate. The collaborative process involves other non-legal neutral professionals, including facilitators, accountants, financial advisors, and business and diversity consultants who can help the parties in breaking through impasse and reach resolution. The parties begin the collaborative process by identifying interests. Next, they develop options. Third, they test the options against the other side's interests. This is followed by testing the options against legal realities. The parties subsequently refine and rank their interests. They then develop mutually acceptable options, followed by proposals, and eventually an agreement. The International Academy of Collaborative Professionals has grown from 200 members in 2001 to 4,400 members in 2011. Approximately 82% of its members are lawyers. There is a collaborative practitioner in virtually every state in the United States. There are 300 practice groups worldwide, 175 of which are in the United States. The average collaborative divorce is completed within 17 weeks. The average litigated divorce takes 17 months. Over the period of October 2006 through August of 2008, IACP surveyed 502 reported cases. Of those cases, 87% were successfully resolved and only 10% were terminated. Recent reports show only 5% attrition. Overall, 90% of the cases settled in less than 10 meetings. According to the Wall Street Journal, the average cost for both attorneys in a collaborative divorce was approximately 2/3 the cost of a negotiated divorce and 1/3 of the cost of a fully litigated divorce. 98.4% of cases settle before verdict. The New York State Bar Association recently reported that there are currently 25,000 wrongful discharge and discrimination cases pending in state and federal courts nationwide. The average jury award was approximately $700,000. The average case took 3 to 5 years before trial. The key differences between collaborative practice and traditional litigation include the following. First, collaborative practice is confidential. The parties have direct involvement in the decision-making. Collaborative practice is fiscally efficient. It is generally less costly and less time-consuming. Fourth, collaborative practice eliminates risk. There is no third-party decision-maker, no judge or jury. Collaborative practice uses neutral, non-legal professionals to diffuse emotion, understand the financial landscape, and encourage communication between the parties. This allows for creative solutions and facilitates a win-win outcome.